Hi everyone, my name is Alexander Zalivako and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. In this presentation, we would discuss the issues of those remedies which are available to persons who or which are subject to the restrictive measures arising under sanctions. And in principle, we will touch the following matters: judicial review and administrative review, which is available for the relevant persons. We will talk in depth about the relevant judicial procedures. And while discussing the judicial procedures, we will discuss about those grounds which were successful when pleading for the annulment of the relevant restrictive measures and which are often pleaded but are not that successful. And we would also briefly discuss the reasons why the relevant grounds are or are not successful. But prior to embarking on this journey, let us briefly address one preliminary point, which is the competent courts. So to the extent the relevant measure in the European Union arises out of the European Act, being typically the regulation of the Council of the European Union, the relevant venue for challenging the relevant measure will be the European courts, the General Court, the Court of First Instance, to challenge the relevant measures, and the Court of Justice of the European Union, either the Court of Appeal for the decision of the General Court, or is a court which can review the validity of the relevant act in the framework of the preliminary review procedure when addressed by national courts. National courts have no power to review the acts of the European Union, and this is a well-established case law. Certainly, to the extent the relevant restrictive measures are implemented pursuant to the laws of national legislation, as would be the case, for example, with respect to arms embargo, or, for example, the measures which restrict the entry of the relevant individuals, then the measures both at the level of the relevant member states which implemented those measures and at the European Union, by way of challenging the relevant common foreign and security policy decision, which was the base of these measures, may be necessary. So the procedures for challenging the relevant acts or applying for their modification may be briefly divided into two major categories. No judicial procedures, where in essence the relevant applicant attempts to interact with the council, being the decision-making body, and in the process of that interaction aims to convince the council that the relevant measures shall be modified or terminated. And the judicial review procedure, where in essence the applicant brings an action of judicial review of the relevant measure in the competent European courts. The first venue of recourse would certainly be non-judicial review procedures, which are often pursued by the applicants in parallel to judicial review procedures, or as the part of preparation for the judicial review procedures. And in essence, the relevant summary is set out in the EU best practices of the effective implementation of the restrictive measures, an internal document of the Council, which is publicly available, and the guidelines on the implementation of the restrictive measures in the area of the common foreign and security policy, which again is publicly available, and which in essence set out the principles of review, the relevant addressee for any application. By way of summary, the relevant principles relate to the situation when either the relevant applicant has been wrongly identified, so there is a misleading or erroneous identification of the applicant, or there is a change of law or facts or evidence, further evidence is available, which requires that the matter is reconsidered by the Council. In summary, the criteria for engaging with the judicial review procedure is that the situation is such that either at the very beginning, because of some erroneous assessment, or over time, the original evidence becomes incorrect in the material respect, or the situation of the applicant has changed in a way that the listing criteria are no longer satisfied. In this case, the applicant shall prepare an application for the review of the measures or for their termination and submit them to the General Secretariat of the Council, which commits them to review and to give an opinion on such application. Another part which can be qualified as a non-judicial review procedure is an inbuilt instrument of control of the sanctions, which is present in any European Union sanctions regime, which is the obligation of the Council to periodically review the relevant sanctions in place and either reconsider their relevance for the relevant listed persons or reconfirm that the relevant criteria and the relevant evidence remains relevant for the continuous application of the sanctions. Typically, the review would happen on a 6 to 12 month basis, and the relevant period of time when the Council is obliged to review and reconfirm or modify the relevant measures in place would be set out in the Common Foreign Policy and Security Policy decision, which implemented the relevant sanctions regime in the first place. So that's as far as the administrative review, where the main interaction is between the applicant and the Council itself. If that process is not successful or is not relevant for the applicant, because the applicant may believe that the process will bring it nowhere, then inevitably the only recourse to the applicant who wishes to challenge the European sanctions is to bring an application for judicial review. And in principle, two venues are available for the applicant. The first venue is the direct action, so direct application with the General Court, whereby the applicant brings an action for the judicial review of the relevant act. And that's the procedure which is set out in Article 263 of the Treaty on the Function of the European Union. Or the alternative to that would be the application to annul the relevant measure indirectly, which would come within the framework of the preliminary review procedure. This one is available for national courts only, and this one would be traditionally engaged as a part of the proceedings in national courts related to the judicial review of those national acts or the judicial review of the agencies or administrative bodies which implement the European Union sanctions at the national level. So as a part of that challenge, which is brought in the national courts may bring an application to the Court of Justice with a request for the preliminary ruling on the validity of the relevant measures in the sanctions area of the European Union law. In principle, as sanctions regimes of the European Union would be adopted as a part of the common foreign and security policy, a question quite frequently arises as to the general competence of the European courts to review those acts. As a general matter, those issues fallen within the area of the common foreign and security policy are outside of the jurisdiction of the European courts. Having said this, there are two clear exceptions to this general rule. The first one, when the review is related to the competence of the relevant decision-making bodies to pass the relevant act. So the review under Article 40 of Treaty on the European Union. This is quite rarely successfully engaged, as typically Council would act within its powers. And the second is the review which relates to the protection of individual rights and individual interests, so individual review, when the European courts retain their jurisdiction, even with respect to those acts which are passed in the framework of the common foreign and security policy. And the European Court of Justice in Rosneft's case confirmed that this applies to both the direct application for judicial review brought in the general courts, and for the review which is conducted by the Court of Justice in the framework of the preliminary review procedure. So what are the circumstances and what are the conditions when an applicant can bring an action for the judicial review of the Sanctions Act? The first is certainly the timing, following the passage of the relevant act. And one has to be mindful that a very short period of time is allocated to the applicant, which is generally 2 months after the date of the publication of the relevant act in the official journal, or the notification to the applicant to the extent counsel is aware of the address of the applicant. As the applicant would typically never know whether the counsel has his, her, or its address, it's advisable, to the extent you see that the relevant sanctions may be applicable to you, to monitor the relevant publications in the official journal on a regular basis to ensure that if you would like to bring this application, you will respect the relevant, relatively short timeframes, which has to be mentioned is generally consistent with very short timeframes afforded also in national legal orders for the purpose of judicial review of national acts. In principle, there is no limitation as to who or what form the person should take in order to bring this action. Any person, in a very generic sense, who is affected by a sanction rule of direct application can bring the action, and the courts, the European courts, confirmed that they would interpret the term very broadly and will not look to legal technicalities. The principle being, if the measure can affect the relevant person, then the person shall be able to bring an action for its judicial review. Having said this, not every measure can be challenged. The measure has to be of direct application to the relevant person. And the whole question often comes up if the relevant measure satisfies this requirement. It is quite obvious that to the extent we talk about asset blocking sanctions, so the restrictions, the effect of which will be that all assets of the relevant person within the territory of the European Union are blocked, and no funds or economic resources can be provided to such person, which will be the typical wording of asset freeze or blocking sanctions used by the Council, then this person will meet the requirements of the individual application of the relevant sanctions and will be able to bring a challenge. There is no doubt about this. Typically, such person will be named by name in the relevant regulation and have the direct and very substantial effect resulting from the application of the sanctions. A matter whether the relevant measure is of individual nature is more complex in the circumstance of so-called sectoral sanctions, when the prohibition is worded by way of restricting certain trade transactions, for example, export and import operations in certain commodities with the relevant jurisdictions, certain finance transactions, for example, prohibits borrowing in certain markets, and other similar measures. These measures can be different in the way they are worded. Sometimes the sectoral sanctions will have a list of the companies. Typically, sectoral sanctions apply to companies or other legal bodies which are affected by the sectoral sanctions. Typically, they would apply to any legal person located in the relevant jurisdiction. Typically, some other generic wording will be used, but the main distinction is that in the second case, the affected person is not directly mentioned in the relevant act introducing the European Union sanctions. Whereas in the former situation, when the relevant person is mentioned by name, it's quite clear that the relevant sanction has individual effect on that person and should, in principle, be able to bring an action for annulment. It is more complex to prove this if the person is not mentioned by name and the sanctions applied for a person at the general group of entities operating in the relevant sector of economy. Having said this, in general terms, the European courts have interpreted the relevant requirement of individual application quite broadly, and to the extent the person can demonstrate reasonable connection of its business operations being adversely affected by the relevant restrictions, preferably by way of bringing examples of existing contracts cancellation, inability to enter into new contracts, inability to find new markets within short terms, or any other similar examples when its business has been substantially disrupted as a result of sanctions, this person should be able to demonstrate that these acts have direct effect on its business and bring an action for annulment. Now we turn to the grounds of annulment, which is probably the key in the process. And the grounds can be broadly subdivided into two large categories. The first one is the grounds of annulment which relate to the violation of some procedural rights related to the designation of the relevant person, provision of information after the designation, the ability of this person to make a submission to the council, and the review procedure. So the procedural rights, which in one way or another, in essence, affect the right to the effective remedy of such person. Effective remedy meaning an effective ability to protect the rights in the courts of the relevant jurisdiction. So that's one group of the grounds which are typically pleaded for annulment. The second group of grounds are so-called substantive grounds, where the pleading is not as much to any procedural irregularities related to how the sanctions were passed, but more to the material, substantive flaws, either in the decision-making process of the council, which, according to the applicant, has not taken into account the relevant facts or has relied on erroneous facts or has not taken into account the change in the facts. In essence, a very similar type of argument which we've discussed as the argument which shall be brought up in the course of the administrative review procedure, as well as additional substantive arguments related to the violation, for example, of fundamental rights, which the applicant may allege are resulting from the relevant measures. So now we would look into the first category of the grounds for bringing up an application for the annulment of the sanction, the procedural rights, where the relevant procedural rights, which often claims, is the failure of the council to inform the applicant of the relevant criteria, and the evidence which was used by the council to impose the sanctions of the applicant, failure to give the applicant the right to be heard prior to adopting the relevant measures, failure to bring additional evidence to the council for the consideration, failure to state the reasons in a way which would be accurate, and failure to provide the access to the file. It's important to understand that these are all procedural rights. It's very difficult for the applicant to actually achieve the annulment of the sanctions regulations on the basis of the breach of those rights, because not only the applicant will need to demonstrate that the relevant rights have not been respected, but also that where these rights respected, the council would have achieved a different conclusion. Now we would look a little bit into more details into the relevant rights. As to the right to inform, the way this right operates, the council is not to inform the applicant before the adoption of the sanctions. The reason for that being that the sanctions are supposed to have a surprise effect, and to the extent the relevant information would be leaked prior to their adoption, the applicant can move the assets or otherwise frustrate the legal effect of the sanctions. For the same reason, the right to be had is not recognized in the circumstances when the sanctions are introduced against the relevant applicant initially, or when the sanctions relate to the measures of general application, typically sectoral sanctions. Nevertheless, the right is recognized with respect to the subsequent reconfirmation of the sanctions, but in the way the principle operates is that to the extent the applicant can provide his or her or its observations to the council, then the courts will say that the relevant principles have been observed by the Council, which in general terms the Council is doing. So the European Council, the Council is engaging into the relevant discussions with the applicants, is providing them the relevant files which relate to their dossier, and is generally actively engaging in the request for reconsiderations, often unsuccessful, but nevertheless the procedure is there. As to the failure to state reasons, given that that's a procedural requirement, the way the courts interpret these grounds is that the reasons shall be stated in a form and in detail which is sufficient enough for the applicant to understand why he or it was listed, and for the courts to exercise the judicial review of the matter. It's not tested at this moment if the reasons were stated accurately. It's not tested at this moment whether there are some material errors in the application of the listing criteria to the relevant applicant. What's important from the procedural perspective is whether the reasons are given in a way which in essence allows the applicant to bring up the application for the review of the relevant measure. The courts will take various points into account when they assess whether that has actually occurred, whether the measures are of general or of individual application, in which case, with respect to general applications, the general context will be very often sufficient to satisfy the requirement to state reasons, the knowledge of the relevant applicant, what's the background of his or her or the company's knowledge. And the summary is that the way the relevant regulations are formulated at the level of the European Union with a very, very detailed preamble, and then the specific individual reasons for listing different companies, individuals, will be often by far sufficient to discharge the Council's obligation to state the reasons for the adoption of the relevant acts. The access to the file may be a ground for annulment only if the relevant access is refused, which normally would not be the case. The right of the applicant to have access to his file is explicitly recognized in the relevant decisions, adopting the sanctions regimes, and in general terms, other than in the case of confidentiality matters, the Council will indeed provide the access to the file. In summary, as by now the Council has very large experience with the adoption of the various sanctions regimes and measures, and these have been often challenged on the basis of procedural requirements. The Council has certainly adopted its procedures and operations in a way that procedural requirements are observed, the relevant rights of the applicants for effective remedy in the European courts are observed, are not infringed, and it's very difficult to challenge the sanctions on this basis, although if we review the relevant decisions of the European courts, they would be inevitably almost always relied as the grounds for annulment. Now we turn to the second group of the grounds for annulment, which are substantive grounds, when the applicant is alleging the infringement of his substantive rights or a misjudgment, substantive misjudgment of the Council with respect to the introduction of the relevant measures. Several grounds have been historically applied by the applicants to annul the relevant measure on this basis. One of them is the allegation of the principle of non-discrimination, of the violation of this principle, whereby an applicant in essence will give a list of the companies being in the same position of the applicant, and in essence would try to make an argument, why me? So there would be 10 companies operating in the relevant jurisdiction. One of them, including the applicant, or several of them, including the applicant, will be subject to the sanctions, and the applicant will, in essence, suggest that it's a violation of the principle of non-discrimination, that out of 10 equal companies operating, in essence, in the same business conditions, the applicant was selected and targeted by the sanctions. This is unlikely to be successful because, in principle, the way the court look at this type of argument is that the fact that the applicant was targeted by the sanctions and the other companies were not targeted by the sanctions, is not the reason for those sanctions to disapply to the applicant, but potentially to apply to non-targeted companies. So in essence, the court is saying that the principle of non-discrimination is countered by the principle of legality, meaning that potentially non-extension of the same restrictions to other entities cannot be relied on by the applicant to challenge the grounds which were relied on by the council to apply the sanction with this particular company or person. The second ground is a so-called misuse of powers, where the applicant would try to point to some procedural irregularities or failure to, for example, do additional due diligence, or failure, for example, to recognize that certain sources of information may not be reliable sources. And the conclusion which is made by the council on the basis of the process. It's important here to distinguish all those irregularities which indeed, in the opinion of the applicant, may result from reviewing the evidence on the basis of which the ultimate decision was made. But the principle of misuse of powers is actually about the point that the council is using the powers granted for one reason for a very different reason. Right? So the powers which are granted in principle for the purpose of, for example, protecting, let's say, common agricultural policy or promoting common agricultural policy, it is used for the purpose of imposing the sanctions in the common foreign and security policy. So the misuse of powers has this very relatively precise legal meaning. And it's certainly very difficult then to demonstrate the misuse of powers in the circumstances when the council introduces the sanctions, because they will be typically made in the framework of the common foreign and security policy, and they would typically, again, satisfy those objectives which the council sets out in the regulation imposing the sanction. Violation of the principle of proportionality will be another grounds, which would be typically pleaded by the applicants in the ER application. The argument will look like follows. The type of measures imposed are not necessary to achieve the objectives announced by the council. Milder measures, milder restrictions may work towards the same objective. Typically, this would be used by the applicants which are, for example, subject to some export restrictions, and they would try to argue that a authorization regime, for example, would be more appropriate to achieve the objectives set by the council than a total prohibition of the export of certain goods and technologies. With respect to this type of argument, again, the courts will generally give substantial discretion to the council to decide as to the appropriateness of the relevant measures. And the relevant test is that the measure shall be manifestly inappropriate to achieve the objectives set by the council. And the argument that the same objectives can be achieved by milder measures will be typically rejected by the courts. Next on the list of the grounds is the violation of fundamental rights guaranteed by the Charter. I give here two examples of these rights. Right to property, which typically will be pleaded in any asset freezes, type of litigation, or right to conduct business, which will be typically pleaded in any type of restrictions affecting access to capital markets or, for example, trade in certain commodities. But these are not exhaustive. Right to family life and privacy would be also often pleaded, for example, with respect to challenging travel bans, to the extent the relevant applicant has the members of his family living within the territory of the European Union. In principle here, the courts accepted the sanctions is a valid means to restrict fundamental rights. And accordingly, the test is whether this restriction is so disproportionate and intolerable so that it impairs the very essence of those rights guaranteed. On this basis, for example, asset freezes, which are temporary restrictions to deal in the assets, rather than outright expropriation of those assets, were classified as not being disproportionate and intolerable to the right of property. Very likely, however, any measures which would indeed result in expropriation would be incompatible, and accordingly, the relevant applicants would be able to challenge them on the basis of these provisions. The last, but certainly not the least, and in fact the most successful grounds for challenge, is the manifest error of assessment for general measures or simply error of assessment for individual measures. This is in essence the most successful ground pleaded for the purpose of the review of the relevant measures introduced against individuals. And the overall argument which is made here by an applicant is that the facts relied by the council for the measures imposed against the applicant were either erroneous at the very beginning due to non-satisfaction of the relevant listing criteria or due to being erroneous in fact, or have changed over time. So for example, the applicant who was listed on the basis of being the shareholder or the general director of a large Russian corporation, for example, resigned from all the positions, disposed of his shareholding, the criteria has changed, and the continued maintenance of such person on the sanctioned lists can be successfully challenged if it could be demonstrated that the original listing criteria have not been satisfied due to the change of circumstances, or in certain circumstances also possible to prove that they were not satisfied since the very beginning, since the facts relied by the council did not demonstrate that these criteria were indeed satisfied. So this is for today. Thank you very much for watching, and I hope that you found this presentation useful.